My Lord, thank you. Just turning to the relevant clause of the contract. It's within the supplemental bundle, page 128.
Yes.
This is the closest we've identified to an express clause permitting the subcontract. It's clear that from many other of the clauses, it's envisaged that subcontracting is permitted, but this is the closest we've got to an express clause permitting it, and that's paragraph 198. The contractor shall not subcontract any of its rights or duties under the contract to any person in relation to clinical matters unless, and then it sets out various things. So, assuming it has taken reasonable steps to do the following, then it's permitted to subcontract. And you'll see from over leaf at 199, there's a requirement to inform the PCT, and just to be clear, whenever an associate is engaged, that is part of the requirement, that has to be done. So they will then inform the PCT that an associate has been engaged.
Yes.
Thank you, that was everything.
Good. Thank you very much, Mr. Davies. You were very patient with us this morning. Mr. Collins.
Well, I'm grateful. Over lunch, I printed off some copies. I emailed Mr. Davies.
Yes, please.
A sample personal dental treatment plan. I ransacked my room in Chambers to see if I could find my original trial bundles, and I'm afraid I couldn't.
No matter.
What I've ascertained and what I've seen is that it's a 2-page document, and it's the front page that matters. The front page has been the same in every iteration of this, going right back to 2006, as far as I can say. As far as I can see, I've printed out the 2020 version just because it came out nice and clearly on paper. But
yes.
I don't think there's any difficulty with the back is from the wrong time period, but the front I think is relevant. So if I could hand those up.
And the rubber stamp would go at top left.
Yes, so the evidence that you see recorded in the judgment that Mr. Rattan said that he would stamp his name, that's the box where the stamp goes top left, provider's details.
And would that be his name, or would it be the practices?
Recollection is that the evidence was his name was included.
He said, according to the judge, he said it was his name.
Yes, it's paragraph 50 of the judgment on page 75. I was shown an example of the form. Top of the form has fields for the provider's details. It's accepted this referred to the contract under the relevant GDS contract, and Mr. Rattan said this box would be completed with a stamp bearing his name. And then there's the reference there to the text on the right-hand side, which says the dentist named on this form is providing you with a course of treatment.
Oh, I see.
You can see that just under the white boxes for name and date of birth. Right. If I may, I'll start where I was going to start and come back to this in due course, having just introduced it at this stage. And what I would like to do, if I may, is to start with an overview, and then I'll descend to greater detail in relation to the two issues of the appeal. And the starting point in our submission is to consider the realities of the defendant's business on the basis of the findings of fact made by the trial judge. And it seems to us that underlying much of the difference in approach which the parties take in this case is a fundamental question as to whether the court had before it a business which was a dental practice providing treatment to patients, as the claimant would characterize it, or, insofar as we understand the defendant's case, two sorts of business running at the same time. We understand them to say that this was firstly a referral agency placing patients with dentists, and secondly a licensing business providing facilities for dentists to treat patients. And I hope in the course of my submissions to be able to show that of course the judge was right to conclude that this was a dental practice providing treatment to patients. It is wholly unreal to suggest anything else. And we submit that the relationships which the court is asked to consider on this appeal, that's the relationship firstly between the defendant and the claimant, secondly the relationships between the defendant and the associate dentists, that all of those relationships fall to be considered by reference to and in the context of the business in which they arise. And I'll make submissions in detail, of course, but can I just make a couple of introductory observations on the facts, starting in the judgment, page 89 of the core bundle, paragraph 104. I've started with the first wrong page reference of the afternoon.
Starters, you mean, to go.
Yes, exactly. In fact, no, I haven't. What we have within paragraph 4 are a series of findings of fact, perhaps starting at the third or fourth line down. But the starting conclusion is that Mrs. Hughes was a patient of the practice in respect of the supply of dental services. They held her dental records and her contact details. They arranged her appointments. Payment was made to the practice. Just starting there. So the claimant attends the practice. She fills in practice forms where she sets out details of her medical and dental history, her contact details. She makes appointments with the practice. The appointments take place at the practice premises. The payments for the treatment she receives, that is both payments from the NHS and patient charges under the NHS scheme, those are made to the practice. And the defendant, in the agreements that he enters into with his associates, describes his patients, of whom the claimant was one, as, and I quote, a patient of the practice. That's the defendant's terminology to which he signs up in the associate agreements. And for your notes, paragraph 43 of the judgment, don't ask the court to turn it up now, it's clause 40b of the agreement, which is page 217 of the supplemental bundle. And in fact, it may be helpful just to turn up this part of the agreement. If I can ask the court to turn up the supplemental bundle, the associate agreement is right at the back behind tab 7. And we look, please, at page 217, clause 40. And the court heard something about the issue of goodwill.
This is the restricted covenant.
In the restricted covenant here, yes. It's rather important, we would submit, and the judge was right to take this into account. The goodwill in the practice is the patients. Whose patients are they? They're the defendant's patients. And all of those terms under 40A are there to make sure that the patients stay the defendant's patients and that the associates don't take them if they move. In particular, 40A3, the associate shall not, for a period of 24 months from the date of his ceasing as aforesaid, that's ceasing to be an associate in the practice, solicit in any manner any person who was at the date of his so ceasing a patient of the practice, to the intent that such person should become a patient of the associate. So both defendant and associates agree that the patients are the defendant's patients, not the associate's patients, and there are provisions to stop them becoming the associate's patients if the associates leave the defendant's practice. And so far as the NHS patients like the claimant are concerned, that's because the defendant's business was to provide treatment to patients in return for payments from the PCT. And we can see from the agreements that there are effectively three roles in all of this. The PCT's task is to procure dental services. The contractor, in this case the defendant, provides those services. And there may be all sorts of people who perform the services. And we see the distinction in the GDS agreement on a number of occasions between providing services and performing services. If one thinks about it, that's necessary for those cases where the contractor isn't an individual, where the contractor is a company or a partnership or some other kind of structure. And that may be an explanation for why there is no specific term in the GDS contract which says it will be permissible to allow other people to perform the services, because that's inherent in the nature of the way the contract is actually structured. But the contractor provides the services to the patients, but there are all sorts of different ways in which that may be done. It's the performers who perform the treatment. And it may be helpful to come back to clause 47. I know the court spent some time looking at this morning in order to make that clear in relation to treatment plans. It's on page 81 in the supplemental bundle. But it would be helpful to have a finger in page 56 as well.
Sorry. Supplementary bundle, page 56 and
81.
And 81.
And I'll start at 81, if I may. Which provides that where the court contractor agrees to provide a course of treatment to a patient. Course of treatment is in italics because it's a defined term. It's defined at 56, and it falls into two parts. This may help clarify some of the questions which arose this morning. There are two parts to a course of treatment. The first part is the examination, the assessment, and the planning. The second part is the provision of the plan of treatment. And the court asked some questions this morning in relation to the fact that when the patient first walks into the consultation room and sits in the chair, nobody knows, of course, at that stage what the treatment is going to be. But the course of treatment as defined in this agreement includes the first phase of examining and assessing and deciding what to do, as well as the second phase of providing the treatment. So that's why I take the court on that short detour to page 56. But what clause 47 envisages is that the contractor is agreeing to provide a course of treatment. and the contractor agrees to provide a course of treatment inevitably when the patient asks to see a dentist and the contractor offers an appointment with a dentist. So the treatment provided by the contractor is the consultation effectively in the dentist's chair, if I can use that as a shorthand. And it says that the contractor shall, at the time of the initial examination and assessment of that patient, the first part of the process, ensure that the patient is provided with a treatment plan on a form supplied for that purpose by the PCT, which will specify all of those details. And the court has now seen a sample in the same terms as that which was before the trial judge. And the court therefore knows that what the patient is told on this form is that the dentist named on the form, so the defendant, the contractor, is providing you with a course of treatment.
And in the definition of course of treatment, page 56.
Yes.
Course of treatment means A, B, provided by, etc., especially provided by others, one or more providers of primary dental services. That's the contractor, not the individual
Yes.
dentist.
Yes. The individual dentists are referred to as performers in this contract. I'll try and take you to an example if I can find one in due course. The combination of clause 47, the form, and the evidence that the judge heard let me take the court to references to a performer so that I'm clear. Clause 30 on page 76. An obvious example. Where the contractor has agreed to provide services to a patient pursuant to clause 25 or 26, I'll come to that in just a second. It shall inform the patient of the patient's right to express a preference to receive services from a particular performer. And 31 shall endeavour to comply with any reasonable preference, but needn't do so if the preferred performer has grounds not to. And just so it's clear what those clauses refer to, if we go back to page 75, we can see clauses 25 and 26. They provide for the contractor to provide services under the contract to any person who requires the services, and it says that the contractor shall provide mandatory services and additional services to any persons, fee-paying adults, exempt adults, and children. So it's the practice which provides the treatment to the patients. It does so through performers. And that tripartite distinction, procurer, provider, performer, as I say, may go some way to explaining why we don't have an express clause in here saying the provider doesn't have to do it himself.
Are the performers subcontractors, or are subcontractors somebody else?
Now, a subcontractor would be if a practice subcontracted some of its UDAs to another practice, in effect to another contractor. And we know that because we see throughout that even where a particular performer undertakes the treatment, it's still treatment provided by the same contractor. So there's not been a subcontractor.
So we've been shown the provision that implicitly gives rise to a right to subcontract, provided conditions are met.
Yes.
Is there an express clause that allows the contractor to engage performers.
No, there isn't, and our submission is it's because it's unnecessary, because those are
That's how it's
but-
inherent
that's
in
what's
the whole
envisaged.
contract.
Yeah, precisely.
Well, it's common ground that the contractor, indeed the contractor is referred to as it rather charmingly. It's not he or she, it's it. So it could be company, partnership, sole proprietor. If it's a company, then obviously it can't perform anything.
Absolutely. And it's one, my lord, was absolutely right at the start of this case to identify that the fact that in this case the defendant happens to be an individual who is a dentist risks distracting us, risks being a red herring. Doesn't actually, it makes it more confusing to identify what is the distinction between a provider and a performer. Had Mr. Rattan been Rattan Dental Services Limited, it would have been entirely obvious that performers would be something other than the contractor.
But although there's not, as my lady has raised, a specific provision regarding performers, I mean, if you just look, for example, at 184, conditions for employment and engagement, dental practitioners, and then it's the contractor shall not employ or engage a dental practitioner. Well, those would be performers, would they not?
Yes.
Yes. And then there'd be a distinction as to the nature of the employment.
Precisely. So there's a series of provisions which regulate
It's in part
the
12.
performers
really,
who
isn't
can
it?
undertake work for the contractor
Yes.
under this contract. Whether they are employed, so of our dentists whose treatment is the subject of allegations in negligence, in this case we have one employee and 3 associates.
Well, it actually says, in fact, Mr. Collins, if we look at page 122,
Yes.
part 12, persons who perform services, and then we have qualifications of performers, dental practitioners.
Yes.
Yes.
So part 12 is all about regulating those who perform the services, and it sets some requirements on the contractor as to what qualifications they need and a number of other matters of which the contractor must satisfy himself. So we could go on, so for example, 189 on page 126, which sets requirements about references. 195 on page 127, requirements to put arrangements in place for maintaining and updating skills and knowledge. 197 on page 128, appraisal requirements.
That's appraisal by the PCT, though,
Yes,
not
So-
by the contractor.
yes, indeed, but it's the contractor's responsibility to ensure that the performers comply with the PCT's requirements. And then coming to perhaps the end of a potential relationship, page 139, clause 229. The contractor shall give notice of writing to the PCT when a performer arrives or leaves the contractor on the date from which yet or is employed or engaged by the contractor. So the PCT has requirements that it wants to know who's performing. But throughout there is a clear distinction between the provider of the treatment and the performers who are actually in the surgery, if I can put it that way.
And it's 198, subcontracting clinical matters. Is that relevant or irrelevant to the present discussion?
It's relevant to this extent that it tells us that it is the contractor, in this case the defendant, who is providing the services, and the defendant as contractor is able to, provided that it meets the requirements set out there, to subcontract somebody else to provide the services.
That comes from clause 47, really, doesn't it?
Yes. Yes, it
Make sense.
all of those terms are consistent with one another in terms of there being this distinction. We have, in fact, I said three kinds of person. I said the procurer, the provider, and the performer, but in fact there's a fourth, it was the patient. And because we are looking at the relationship when we come on to the non-delegable duty ground between claimant and defendant, the idea that all of this is irrelevant when it is all there to set out how the defendant will deal with patients like the claimant, we say is plainly wrong. By signing up to this agreement, the defendant says what he will do about providing NHS dental services to patients of the practice. And of course that's relevant to understanding what he did with this patient of the practice and what the relationship was between them. So, from a learned friend suggests that the obligations which the defendant owed to the PCT are, the note I made was entirely separate from the relationship between claimant and defendant, just makes no sense. It's the contract which governs the treatment which the defendant provides to patients, such as the claimant.
And just, I'm sorry, can I just understand? Mandatory and additional services.
Yes.
Mandatory services are dealt with in clause 74, and they must be provided.
Yes.
And they must be provided during particular times. Is that right? Or is that just urgent? That's urgent treatment. Oh no, during normal surgery hours. What are they? What's the difference between mandatory and additional services?
So mandatory services are listed at clause 76.
Oh yes. So that's the sort of standard.
Most things are mandatory.
Yes, that's right.
Some, I would guess, cosmetic isn't, but anyway,
So
76
it's
is
necessary
pretty comprehensive.
dental care and treatment.
Yes.
And that the contractor must provide to its patients.
Yes. And for your reference, additional services are described from clause 101 on page 100. They include advanced mandatory services, and then an awful lot of things which have been crossed out.
Yeah. Okay. So it's the mandatory services that are the focus, really.
I suspect the services that are in issue in this case are all fall under the umbrella of mandatory services. I'll get a tap on my back if I got that wrong. That's my assumption. But the important point is they are services provided by the defendant to patients.
Yeah. And clause 41 makes that clear.
Yes. And then, just to take this right back to the beginning, if I can ask the court to turn back to page 52, the preamble, headed background, D at the bottom of 52, the PCT and the contractor wish to enter into a general dental services contract under which the contractor is to provide primary dental services and other services in accordance with the provisions of the contract. So the very starting point of this is that the contractor will provide services and we know that that means services to patients from page 61 in the definitions section. The second to last definition, patient means a person to whom the contractor is providing services under the contract. And indeed, over the page at 62, the second definition, practice, means the business operated by the contractor for the purpose of delivering services under the contract. All of these many clauses in the contract point to the same thing, which is that this is a business, not licensing surgeries at dentists, not arranging referrals. It's a business providing dental services to patients. That's what the defendant's business was. It was no doubt a valuable one. And we respectfully submit that all of this rather complex analysis put before you by the defendant on his behalf about license fees and arranging treatment is an attempt to place a construction on these relatively straightforward facts, which is highly artificial and really can only serve the purpose of avoiding the obvious conclusion that the defendant's business, which took the financial benefits of providing treatment to patients, should also be liable to those patients if the treatment for which it was receiving money was provided negligently. And to borrow some of the analogies which the court raised this morning, if the defendant in this case wasn't providing treatment to his patients, as the defendant suggests, we could equally say an NHS trust isn't providing treatment and is not liable to those who attend an outpatient clinic. We could equally say, well, all that's happening is that the trust is arranging for the patients to be seen by doctors and nurses who are using its premises and equipment. And we know that analysis is wrong, whether or not the negligent individual is an employee, because Lady Hale tells us that in Woodland. If I can ask the court to turn to the authorities bundle. It's a passage which I highlighted in my skeleton. I may have spotted it before. It's tab 6 in the authorities bundle. Page 317. Paragraph 34. No one in this case has seriously questioned that if a hospital patient is injured as a result of a nurse's carelessness, it matters whether the nurse is employed by the hospital or by an agency. If we are to apply that dictum to this case, the defendant is left with the task of establishing that where a dental patient is injured as a result of a dentist's carelessness, it does matter whether the dentist is an associate like Dr. Furr or an employee like Dr. Khan. And we say that the defendant can't do so, and the judge below was right so to find. And just before I get to the two grounds of appeal, just this last general point about the fact that it happens to be that the defendant is a dentist. I said at the outset that the defendant's case in reality is that this business is a combination of two things, a referral agency and a licensing business. That's the way it's put to you, but actually, it's got to be three different businesses operating at the same time. the referral agency, the licensing business, and a dentist practice as well, because Mr. Rattan provided dental services himself and he employed Dr. Khan to provide dental services. So on the defendant's case, at one moment this is a referral agency, and the next moment it's a dentist practice. And it simply doesn't make sense. So, my lord, my ladies, that's my general introduction. If I can turn then to the specifics of the two grounds of appeal, and I'll start with
just
delegable
before we
duty.
leave,
Yes.
Lady Hale at paragraph 34, Woodland,
Yes.
before we get into any detail of the hospital cases, I suppose there is this difference. Maybe you say it makes no difference in law. Dental treatment, by its nature, is one individual dentist, possibly with the assistance of a dental nurse. Whereas hospital treatment is often given in teams. And it would be very odd if a patient who is operated on in hospital had to distinguish and sue separately if anything goes wrong, the surgeon, the anaesthetist, the houseman who's assisting the consultant surgeon, and so on. Does that make any difference?
There are two points that I need to make in response to that. First is that it doesn't make any difference because it's a matter of happenstance whether the treatment that any individual needs in a hospital happens to be from an individual or for a team. There are plenty of outpatient clinics where one goes in and one sees an individual nurse or doctor. Fracture clinic, perhaps an obvious one for a simple injury along those lines. So the fact that it's a hospital doesn't really tell us much more. Of course, it's right to say that it would be very unsatisfactory if a patient had to bring different sorts of claims in respect of a single team. But it would be equally unsatisfactory for them to have to find out the employment status of the doctor or nurse who saw them in the fracture clinic before deciding who to sue. But the second point to make is that brings us back to a dental practice where a patient like the claimant in this case may not be seen at one moment in time by a team, but over a period of time is likely to have a number of dentists working on her teeth, and not infrequently one particular tooth. And one of the difficulties that dental claimants have historically faced is trying to deal with this multiplicity of defendants. So there's a practical difficulty, and I set a little bit of that out, the practical background to it at the start of my skeleton, and I referred you to the decision of this court in Pawley and Whitecross Dental Services very recently, which recognises those difficulties. But it would be an oddity in any event if Mr. Rattan were to have a different liability according to whatever particular contractual arrangements have been put in place with the particular dentist. So we are in, albeit the practical circumstances are in some respects different than some hospitals, the issues of principle are the same.
Yes, sorry, I diverted you from taking
Taking
us to your next point.
The court prerogative. I was going to turn then to the first ground and non-delegable duty. And I know the court's already looked at Woodland, so I'm not going to go back to paragraph 23, which really sets out the matters that we need to consider. There are three in issue, although I sensed something of a retreat on the first from my learned friend this morning. So I'll deal with the first feature, namely whether the claimant was a patient, relatively briefly. Because the submission that we made in our written skeleton was that actually the issues which the defendant sought to rely on in relation to the first feature really went to the second feature. Of course, the claimant was a patient. She was undergoing a form of clinical treatment. By doing so, she was particularly vulnerable to a risk of injury. So insofar as the defendant suggests there's no magic in being a patient, legally speaking, he's wrong. There is. Being a patient is a gateway to the conclusion that the defendant owed the claimant a direct non-delegable duty. Lord Sumption at paragraph 23 of Woodland identifies a few categories where we don't need to think too hard about this. Patients, children, prisoners, residents of care homes, they are obviously especially vulnerable to injury. So any proposition that the claimant isn't a patient for these purposes, we say, is unsustainable. The judge's conclusions there, for your note, paragraphs 104 to 108, contain no errors. The real question we would submit that the defendant relies on is this question of the antecedent relationship. Was there a relationship which placed the claimant in the care of the defendant? I've made a number of submissions this morning trying to pinpoint the time of this antecedent relationship. And in my submission, it's not really necessary to do that. The question is, at the point when the claimant underwent the treatment about which the allegations of negligence are made, was there already, from whatever point in time it may have been, a relationship which placed the claimant in the defendant's care, and from which it's possible to impute the assumption of a positive duty to protect the claimant from harm. And that's partly why I started where I did, because I respectfully submit that those introductory submissions that I made about the nature of the defendant's business may be the starting point for thinking about this issue. You've been taken already to Farage, but can I ask you to have a look at it one more time, please? Tab 3 in the authorities bundle. Paragraph 88, which is page 167. Where Lord Justice Dyson assumes that a hospital generally owes a non-delegable duty to its patients to ensure they're treated with skill and care, regardless of the employment status of the person who is treating them. The rationale being, this is the important part for our purposes, the hospital undertakes the care, supervision and control of its patients who are in special need of care. Patients are a vulnerable class of persons who place themselves in the care and under the control of a hospital, and as a result, the hospital assumes a particular responsibility for their well-being and safety. And I respectfully adopt my Lord's proposition that under the care and control of doesn't mean that they're unconscious or lacking capacity or anything along those lines. When one submits to a clinical practitioner to receive advice and treatment, one is under their care and control. And we say the proper approach to this case is that the practice undertook the care, supervision and control of its patients. And that this case can be contrasted with the facts of Farage, and the claimant in that case failed, because they were never a patient of the defendant's hospital at all. That's paragraph 92. Just beyond halfway down, sort of between F and G. Well, in fact, to begin with, about 6 lines down, it identifies the claimants were not admitted to KCH for treatment. KCH provided diagnostic and interpretive services, but there's no reason to suppose those services couldn't have been provided by a specialist laboratory or testing house rather than a hospital. In my judgment, there's a significant difference between treating a patient who's admitted to hospital for that purpose and carrying out tests on samples which are provided by a person who is not a patient. Such tests are not necessarily carried out in a hospital. The special duty that exists between a patient and a hospital arises because the hospital undertakes the care, supervision and control of persons who as patients are in special need of care. So that's a bit closer to a referral scenario, but actually it's something quite different. It really, in that case, is a hospital case almost by coincidence that the defendant, which was providing laboratory and analytical services, happened also to be a hospital. Perhaps the better contrast is the Ministry of Defence case, a child, which is referred to by Lord Sumption also in Woodland. Perhaps I can take you to that in Woodland. So tab 6, paragraph 24 of Lord Sumption's judgment, which starts on page 312. A was a claim brought by or on behalf of a child who was injured in a German hospital. The parents being a service family posted to Germany at the time. And what the Ministry of Defence did was that they, with the assistance of an English NHS trust, I think it may have been Guy's and St Thomas's, but I may have got that wrong, made arrangements with to have service personnel and their families admitted to local German hospitals and to be treated there. And no non-delegable duty arose in those circumstances. If we go over to 313, we can see why. The actual, so right at the top of the page, the actual result in A was correct. The Ministry of Defence was not responsible for the negligence of a hospital with whom it contracted to treat soldiers and their families. But the true reason was the finding of the trial judge that there was no sound basis for any feeling that secondary treatment in a hospital was actually provided by the Army, as opposed to arranged by the Army. There was no delegation of any function which the Ministry had assumed personal responsibility to carry out, and no delegation of any custody exercised by the Ministry over soldiers and their families. So that's closer to an arrangement case. But the MOD wasn't arranging for the patient to be seen by doctors in its own hospital. It's an arrangement case because all it did was arrange somebody else's hospital to agree to admit the patient. And I don't ask the court to look at it now, but for your note, paragraph 70 of the judgment deals with A, and it deals with it correctly. The circumstances here, where the defendant was providing treatment within his own practice, are of course wholly different, and the part of the judgment which is perhaps of most assistance here arises. I can ask the court to go back to the core bundle, page 90, is where the second factor is addressed. Paragraph 111 on page 91, where we see those factual matters, those findings which make it clear that this is treatment provided by and at the practice rather than arranged somewhere else. And the judge goes on at 112 to say that the claimant's own perception doesn't in itself carry weight. I invite the court to say that might be going a little far. Plainly, it's not determinative, and plainly, Lord Justice Dyson to say that that would be a pretty uncertain test. But if the patient's perception is consistent with the objective features of the relationship and is consistent with what appears to be set out in the contracts, it may be a small factor, but it's a relevant factor, we would suggest. One further short point to make about hospital treatment. My learned friend said, I think this morning, and certainly said below, that there's a difference between a dental practice and a hospital, because a hospital is under an obligation to accept a patient. And the circumstances under which a hospital may or may not be under that obligation might be a little bit more complex than that, but it doesn't actually matter, and this court won't be required to decide it in my submission, nor was the judge below required to decide it, because it doesn't matter whether the practice or the hospital has to accept the patient. The question is whether they have done. This practice did accept the patient, and the question is whether that gave rise to the sort of relationship which meets the requirements of Lord Sumption's second factor in Woodland. And that leaves me then to deal with the question whether the judge was wrong to take into account the GDS contract and the associate agreement. The court has had my introductory submission on that, and in fact there's probably not much more I need to say. It's a surprising submission. It is straightforwardly wrong in our submission. Of course the judge must take all of the circumstances into account. If there is a disagreement as to what was the nature of the services provided by the defendant, as in were they treatment services or referral services, documents agreed by the defendant which set out what services he would provide must necessarily be of assistance in understanding the relationship between claimant and defendant. We would suggest they're crucial to that understanding. And indeed, if I can take the court back to page 67 in the judgment, the list of agreed and disputed facts. It was agreed, and it is agreed, at paragraph 4, that NHS dental care was provided at the defendant's practice pursuant to a contract between the PCT and the defendant, under which the defendant contracted to provide dental services to patients at the practice. The idea that the contract in those circumstances is irrelevant and had to be disregarded by the judge, I respectfully say, is a surprising one. I won't go through them all. The findings of fact start at paragraph 12 in the judgment. The contract, or those findings of fact about the contract, are consistent and all consistent with the practical reality as the claimant experienced it. If we then jump ahead to the conclusions which start at paragraph...
Just before we leave the agreed and not agreed facts, it doesn't seem to me that the so-called areas of factual dispute, there isn't really any head-on dispute. In the claimant's account and the defendant's account are almost compatible.
Yes.
The claimant seems to deny that, she says, at no time did she choose which dentist treated her. She was simply given an appointment with a named dentist. That may not be correct at all stages, but that apart, I'm not sure that there's any great difference between the two sets of facts.
Dig out the agreed practice document itself.
Well, I think the judge has faithfully recited it.
Whether I'm just checking that the disputed facts are.
Page 4.
Yes, I'm just checking whether the judgment have been. Oh yes, in the second part of paragraph 9 of the judgment.
Yes.
Reflects
Yes.
paragraph 5 of. I'm so sorry. Page 5 of the supplemental bundle. Where you've got the original. One thing that I would pause to observe is on that list in the disputed issues, the last issue, issue 12 on page 6 of the supplemental bundle, whether the claimant was a patient of the practice at the relevant times. The parties had at the forefront of their minds that that was an issue. I heard quite a number of times this morning a suggestion that perhaps the pleading wasn't clear enough, or the parties of claim weren't clear enough, or that the defendant may have been taken by surprise in the course of cross-examination, and none of those submissions are tenable. None of them begin to be tenable. The issue between the parties was whether liability arose in circumstances where the claimant was the patient of the defendant's practice. So I was going to take the court to the translation of those findings of fact into the judge's conclusions, which are on page 90 of the core bundle. So in particular at paragraph 110, we have the significant findings under the GDS contract. None of which are susceptible to criticism in our submission. And then I've taken you to paragraph 111, which has the practical arrangements, if I can call them that. Paragraph 112 looks at the claimant's own perceptions, and I've addressed that. But the judge's conclusion at the end of 112 is important. The factors that gave rise to Mrs. Hughes' perception, specifically those identified at 111, are themselves relevant objective indicators that she was, for present purposes, a patient of the practice. And we say that that is important. And she then goes on properly paragraph 114 to see whether there are any elements of the associate agreement which shed any light on the relationships. And there are, and she properly addresses those in those sub-paragraphs under 114. The county court cases are addressed at 117 and 118. Unless it will assist the court, I don't propose to look at those. They're different cases on different facts, albeit that they reached similar conclusions. And all of that passage explains the finding at the beginning at 109. There was an antecedent relationship between claimant and defendant which placed Mrs. Hughes in Mr. Rattan's care in respect of the provision of dental treatment, entailing a positive duty to protect her from harm caused by that treatment. The arrangements made between claimant and the practice, the terms of the GDS contract, and the nature of the associate agreement all support this conclusion. That is, in our respectful submission, unanswerable logic. Those are the submissions that I wanted to make on the second factor. The third factor I can take much more shortly. A third feature requires the court to consider whether the claimant had no control over how the defendant chooses to perform his obligations, so whether personally or through employees or through third parties. And that's exactly the situation, of course, that we have here. The defendant could perform the obligations through an employee like Dr. Carr, or an associate like Dr. Furr, or himself. The claimant had no control over that. She could make a request. She could refuse care altogether and go somewhere else, but that doesn't take us anywhere at all. That's true of every patient in every clinical setting. They can decline to consent to treatment from any particular practitioner. And the judge's reasoning on this issue, which is put relatively and rightly shortly at paragraph 119 on page 93, we say is right. Learned Friend referred below to a case called GB, which noted that a patient held in detention inevitably had no control over how they were dealt with. Perhaps inevitably the judge found that obviously that's true, but it doesn't mean that a patient who isn't in detention necessarily does have control. So GB doesn't assist us at all. All of those matters are properly dealt with at 119 and 120 of the judgment. Features 4 and 5 are not in issue, and on that basis we submit that the judge's approach and conclusions on the issue of direct non-delegable duty were demonstrably correct, and we'd like the court to dismiss ground 1. Unless there's anything further I can assist with on that topic, I'll move on to vicarious liability.
Yes, please.
The parties are agreed, I think, that it was right for the judge to consider as an important question whether the associates were working in and for their own businesses, or whether they were working in and for the defendant's business. And that's described by the judge in this case at paragraph 126 as the most significant question. My learned friend sought to suggest that there's a mistake in the reasoning here because of a distinction drawn between working as part of their own independent business or as an integral part of the business. In and for are the words used, I think, in the judgments to which the judge refers. In particular, that expression I think crops up in Cox, but there's no doubt, and certainly Lady Hale's judgment leaves us in no doubt, that the question of whether the individual is working in and for their own business is an essential one to consider. And the judge, we say, was right to do so in this case. And we say the judge was right to take as her starting point that the work the associates did was work which enabled the defendant to fulfil his contract with the PCT, whereby he undertook to provide dental treatment to patients of the practice in return for payment. Without the associates, he could not have run that business. The work of the associates was integral to it. They were working in his business. They were working for his business. They were generating his income.
But you can do that as an employee, or you can do that as an independent contractor, and the PCT contract envisages both.
Yes.
So it doesn't tell you anything. It's neutral, isn't it?
Well,
isn't the real question the extent to which they are in control of their hours and the amount of work they do, and whether they work for one dentist practice or several dentist practices?
those are questions which may assist, but it's still necessary to consider whether they're in business on their own account.
Well, doesn't the amount of work they do determine how much they will earn, and therefore, to that extent, they are in business on their own account?
If that was so, then everybody working under a 0 hours contract, for example, would be treated as a
They're
independent
workers.
contractor.
Well, the Uber drivers are workers rather than employees.
Yes.
There's a broader
But
definition.
we're not looking at whether the associates are employees. We're looking at whether they're in a relationship akin to employment.
Yes.
So we know they're not employees,
Yes.
in actual fact.
Yes.
And workers may well be in a relationship which is akin to employment, depending on the question that we have to decide whether they are in business on their own account. Lady Hale said she was tempted in Barclays Bank to align the two analyses and said the worker, there was some attraction in it.
Yes,
But that it wouldn't be right to do so.
Yeah.
Can I start by thinking about just the example of the Barclays Bank case, which is a doctor who's seeing patients of the bank. Just by way of distinction with
Was it
employees.
at the bank?
Yes.
Oh, yes.
On bank premises?
No, it wasn't on
No,
bank
I
premises.
didn't know it
No,
was.
they were pre-employment medicals in
Yeah.
effect.
They were
Yeah.
pre-employment medicals and some very occasionally during the course of employment. And they took place at the doctor's premises.
And he's working for the bank, providing services to the bank in those circumstances. What the doctor is not doing is providing banking services to the bank's customers, risk of stating the obvious. Here we have a situation where the associates whose status we are concerned with are providing dentistry services to the practices clients. And we can see straight away the distinction between an independent contractor, in this case a doctor providing all sorts of medical services to all sorts of people, to an individual who is not an employee, but who is working in circumstances which are sufficiently akin to that to make it appropriate that the dental practice should be liable. And some of the issues that my lady raises might be a pointer one way or the other, but not necessarily, if I can put it that way. And there was a long list of factors which my learned friend set out in his skeleton, which include some of the matters that my lady just referred to. And in fact, it's possible to have all sorts of features which might be consistent with a relationship more or less akin to employment. So, for example, number of hours is a feature which depends upon the terms of the particular contract. So it may be that hours are variable in an employment contract or a non-employment contract.
But at the whim of the associate dentist, the associate dentist can decide how many hours to provide and when and on what days.
Yes.
Whereas an employee or worker is more likely to be directed by the employer or organiser.
I hesitate to assume that the same approach applies to employees and workers. There will be the Uber drivers are the obvious example of individuals who may not be directed as to when and how many hours they put in. The fact that they can go and work for different dental practices doesn't take us any further either. It's possible to have half a dozen part-time employments, for example, all of which include a status as an employee.
But my lady draws an important distinction, as it seems to me, between the case, in this case, if the associate dentist says, perhaps with a bit of notice, I'm going away for February, whether you like it or not, he's entirely free to do so. Under the 0 hours contract, which is so much the topic of political debate at the moment, it's the supermarket or whatever that says, we want you next week for 40 hours, and the week after that you can go and stuff it.
The contract's a little odd in that regard because it does have provisions about holiday entitlement.
You can't take more than 21 days.
Yes.
Right.
It's rather difficult to reconcile with.
But is it?
Well, with the defendant's case, which is that they can do whatever they like and they don't have to turn up at all. Now, how that's reconciled with a maximum holiday entitlement is rather difficult to understand, and it suggests that the reality of this is that, as the judge found, the defendant relied on the associates to deliver at least a minimum level of UDAs. I don't know whether the court has seen this. There is a provision in the contract, the associate agreement, which is left blank in this case. The model BDS agreement says the associate agrees to provide X number of UDAs per annum. So in one of the county court cases, for example, breaking that was a significant factor. There was a minimum expectation, and Mr. Rattan's evidence before the court below was that he didn't fill it in because it was just always understood it was not a problem. Everybody was going to pull their weight and it would all be sorted out. So there was an expectation that the associate would be providing these UDAs, that they would.
But if they didn't, he could always take on many more associate dentists, couldn't he? He could have 10 or 20 associate dentists, only able then to work a day here and there.
Yes. But he would determine, if he's got a pool of 20 dentists and I don't know how many surgeries there were, let's assume there were 6 treatment rooms in the practice. He will determine when the rooms are available, what staff are made available. The associates can only work in circumstances where he makes the premises available for them to work.
I thought he was obliged under the PCT contract to make the premises available from 8:30 on a Monday to 5:30 on a Friday to
Yes, but
deal
not
with the mandatory services.
Yes, for the patients,
Yes.
but not for the
not-
associates.
Not for the associates.
Not necessarily
Yeah.
all 6 of them.
Yeah.
Whatever.
Okay.
But you know, Mr. Collins, the points raised by my lord and my lady are very, they're very much part of the working environment. Let's take a smaller point, which is just they can choose which lab they want to use.
Yeah.
Now that really does give them control. It's control over 2 things. One, no doubt dentists have their own particular labs because they know the labs produce the work of the quality they want. Well, that will directly impact on the amount of money they generate, doesn't it? Because they have to pay the lab's expenses.
Yeah.
So you've got 2 aspects of control there. You've got the clinical control and you've got the financial control, both of which are left with the associate.
Well, I don't accept its financial control. There are decisions that almost every person who works in whatever capacity has to take, which will affect how much money they take home at the end of the month. From how they choose to dress, so we talk about uniforms and in this case, how they choose to travel to work, whether they want to go on a first class train ticket or a second class train ticket. Choosing which lab doesn't amount to an element of control. It's simply a decision as to how to go about the business which they're required to perform in order to be paid the money that they want to be paid.
Yeah, but that's it. The money they want to be paid.
Yeah,
and
which
it is
is
directly controlling the money they want to be paid.
Well, which derives expressly from the negotiation which the practice undertakes with the PCT. So the practice obtains the fee from the PCT. The dentist gets 50% of whatever it is that is negotiated. So that's the wage that they are paid by the dentist. Now, arrangements are made for them to pay lab fees, but a nurse working in a hospital will choose, for example, what watch to use, what nursing watch to use, or what uniform to put on, and that will affect their income as well. And it makes no difference whether they're a bank nurse or an employed nurse?
Well, first of all, the nurse will be provided with a uniform. She won't choose what uniform to use.
Bank nurse may not be.
But we're not.
And if the bank nurse then chooses to undertake employment, they may well have their own uniform.
That's
Doesn't
completely
necessarily follow.
different from deciding which laboratory to send the clinical sample that you've taken to. It's just it's miles away, isn't it?
Well,
This is you described the submissions on the other side as unrealistic. This is wholly unrealistic, isn't it?
well, in my submission, no. Although it's factually a different sort of expense, it's simply a question of employees or workers or contractors choosing how they want to, what money they want to spend to be able to do their job well. An employed solicitor may wish to buy books. An employed doctor may choose to go on particular kinds of CPD courses. That doesn't stop them being an employee, and it affects the profitability of their work at the end of the
But
the
in
year.
general, an employed solicitor will have an allowance for books, and training will be provided by the employer. Here,
Depends on what firm they work for us.
but anyway, all right, we've taken it probably as far as we can.
I must say, it's hardly your best point to say that it's up to the individual dentist whether they come to work by first-class train or second-class train. Of course, it's open to everyone. So what? Why is that an indication of akin to employment as against genuinely independent contractors?
It's not of itself an indication. It's a perhaps badly expressed way of arguing it the other way, to say that decisions taken by those who work as to whether they want to get hold of expensive goods or services to do their job or cheap goods and services to do their job isn't really a very helpful way of distinguishing whether they're in a relationship akin to employment or not. Whether I'm right or wrong about that, and I have a sense of what the court's view is as to whether I'm right or wrong about it, the judge has looked at these issues, and that's the important question. The factors that she goes through may not have everything on the 25-point list or however long it was that Mr. Davies set out in his skeleton argument, but it does identify the key issues. So it looks at paragraph 124 at the variability of income. It looks at the freedom of how much time they worked at the practice and how they divided their work there between NHS and private patients. And she accepted that that degree of freedom cast some light on the nature of the relationship and could be an indicator that they were independent contractors. All of that reasoning is correct. None of these features are of themselves determinative, but it was right for the judge to take them into account. She goes on to look at control at paragraph 125. She looks at freedom to make clinical decisions. That's a non-starter for the defendant, we would respectfully suggest, because clinical freedom is entirely consistent with the relationship of employment. It's how they work rather than what work they do that is of key importance. And then there are the issues relating to control, which are set out in the 8 subparagraphs under 125. And my learned friend suggested that there was an error here in that the judge had treated this as a threshold test. And our respectful submission is that's not the way that she's approached it at all. She does have to look at whether there is sufficient control. That's not a threshold, that's part of the weighing of all of the features which she considers across this section from paragraph 1, 2, 4, 5, 6 and onwards. There isn't, of course, a specific threshold of control. The amount of control must be weighed against the features pointing in both directions. She takes into account those 8 factors there, and she is, in my respectful submission, right to do so, and she's entitled to do so. She then goes on at 126 to look at the extent to which they were working as part of their own independent businesses. And 127 deals with those factors which are also relevant. And she concludes, in light of those 4 paragraphs over 3 or 4 pages, that the relationship was sufficiently akin to employment to make it fair and just to impose vicarious liability. And so, having looked at the proper factors, as we say she has done, and having weighed them properly in the balance against the test which she identifies at the start of the passage, there isn't, quite simply, any error of approach or error of law here. Which leads me in effect to the last of my learned friend's criticisms, which really wraps up the three points he made together. And they are these. He says there was a requirement that all of the factors be taken into account. We say they were. He says it's important that control was not treated as a threshold requirement. It wasn't. And he says it was important that the question of integration into the defendant's business was recognised to be just one factor. Well, plainly it was. And in those circumstances, there's no error on the part of the judge, and we invite the court to dismiss ground 2 as well. May I turn my back to check I haven't missed something?
Of course you may.
Those are my submissions.
Thank you very much. Mr. Davies.
Lord, my ladies, I've just got one point in respect of each of the issues that we have to deal with.
Yes.
Firstly, in respect of vicarious liability, my lady raised a point about the choice of lab, and that was potentially indicative of the associate having control of clinical decision and also control of income. I'd add just this, that it also potentially indicates a control of business reputation, because if the associate chooses the best lab, receives a perfectly fitting crown, for example, that's very high quality, that will reduce his income, his or her income, in respect to that item of work, but it may increase the likelihood of the patient returning for further work or recommending the associate to family and friends. So that is a business decision in terms of the associate's reputation in respect of that particular individual that the associate has to make, and that's one additional matter that can and should be taken into account. Then turning to the issue of non-delegable duty, I do say that it is important to be clear about the matters that should and should not be taken into account when assessing the antecedent relationship, and in particular whether that gave rise to an assumption of responsibility. No duty of care can be assumed by pure silence in an action. There has to be something positive done or said to the claimant, whether with words or actions, to give rise to such an assumption of responsibility. And that is why we say things done or said or agreed with third parties do not assist unless they also result in something positive said or done in relation to the patient. So it forms part of the antecedent relationship with the patient.
And isn't the treatment plan a primary example of that?
in this case, the only factor that was part of the antecedent relationship with the claimant that could be said to be a positive factor, suggesting that the practice had assumed a duty to provide treatment, is the dental treatment plan, which I think is paragraph 111.4, and it's the second part of that paragraph. All of the other factors, so 1 to 3 and the first part of 4, we say are essentially neutral because they're equally consistent with the practice essentially making arrangements for the provision of dental treatment by the associates. So in short, we should not be looking at what was agreed with PCT. We shouldn't, we can only conclude that points 1 to 3 are essentially neutral, and then you have the dental treatment plan, which is the only factor that could potentially be suggestive of a positive act indicating a duty to provide treatment. And the reason it's important is because there are many other situations involving patients where it will be important to be clear about the matters that should and should not be taken into account when deciding what duty of care has been assumed and whether a non-delegable duty is owed. And for example, they would include treatment provided at a private hospital by a consultant and treatment provided by a locum GP at a GP practice. Those aren't matters that you need to consider because they will depend on the facts. But it is important to be clear about the matters that need to be looked at and can be properly taken into account when making that decision. Thank you.
What I should have said before I sat down, I'm just so sorry, is that that long list of factors in relation to vicarious liability I haven't addressed you on orally. You've got a written answer to each of them in my skeleton.
Yes.
I would just ask the court to look at the written answers. That would take a long time to do.
We'll look again at the skeleton arguments you both helpfully provided. We will, of course, reserve judgment, send out a draft to council in the usual way, not for re-argument, but for correction of any obvious errors and so forth. We will do that as soon as we can, but you've given us a good deal to think about, and it is an important case. Thank you both very much.